A warm welcome to episode 3 of the No5 Court Protection podcast. As lockdown restrictions ease, life and the pace of practice in the Court of Protection quickens. This episode is focused on urgent applications and injunctions, and we want to bring you a really practical focus on these topics. In Court of Protection, those of us at the coalface generally know when the time has come to move fast and to move decisively. Urgency makes the difference, after all, between practitioners, proclaimers and procrastinators. Well, there are no procrastinators here. I'm delighted to be joined by 3 speakers who are going to deal with these interesting and important issues. We have Varsha Jagadesham, who's going to tell us about urgent applications, joined by Katie Webber, our guest speaker from Ashford Solicitors, who will offer us her perspective as a solicitor and some very useful hints and tips. And then we'll have David Gardner, who's going to tell us about injunctions in the Court of Protection and tell us in particular about the decision of Mr Justice Keehan in Re SF, followed with some very practical examples from his own experience. And again, Katie's going to offer us her perspective as a solicitor on that. So over to Varsha.
Thanks, Adreeja. As Adreeja has said, I'm going to provide a roadmap for bringing urgent applications to the Court of Protection. And Katie is going to tell us her experience as a solicitor who has brought numerous such applications. And Katie, I don't think that's an overstatement to say that. Then, right at the end of our section, we're going to consider capacity evidence in the context of urgent applications, the difficulties that might arise, and how these can be dealt with. So, the important thing to remember is that the Court of Protection can deal with urgent applications 24 hours a day, every day of the year. And it's important for COP practitioners and health and social care professionals to remember that this applies even now, during this period of national public health emergency. Indeed, it may be the case that because of circumstances arising from the COVID-19 epidemic, that urgent applications will need to be made. For example, in recent weeks, we've seen urgent applications to authorise the move of P from the care home to the family home. The relevant practice direction is Practice Direction 10B, entitled Urgent and Interim Applications, and this is available online. First, a note of caution at the start of the roadmap. There will be cases where urgent applications arise simply because applications have not been pursued sufficiently promptly. Now, the Court is alive to this, and the practice direction makes it very clear that this is undesirable and should be avoided. A judge who has concerns that a process might have been abused can require the applicant or the applicant's representative to attend at a subsequent hearing to explain the potential delay. So, it's vital that practitioners don't leave things to the last minute, whereby they are forced to make an urgent application. Second, when do you bring your urgent application? The practice direction states that wherever possible, urgent applications should be made within court hours. Now, prior to lockdown, such applications would normally have been dealt with at court, and it was only in cases of extreme urgency which would be dealt with by telephone, and the practice direction provides a number to call. However, during lockdown, it's been the case that urgent applications have by and large not been happening physically at court. Katie, I know that you've had some very recent experience of bringing an urgent application during lockdown. Would you be able to tell us how that went?
Yes, of course. I think certainly it was slightly more challenging, particularly in the early stages of the lockdown period. More recently, I think things have settled down a bit and the processes are a little bit more clear. Certainly, from a practical perspective, when thinking about how to get an urgent hearing listed, it's important to think about what tier of judge that you're going to need to hear that application. and whether it's possible to get the application in front of the appropriate tier of judge in a regional hub that is as close as possible to P. While P may not wish to attend the initial hearing or even be on the line, it's important to take account of the fact that hopefully at some stage we'll be able to return to court and P may wish to attend and be more involved in the process. So it's still vital that we're issuing regionally if at all possible. Of course, there are some circumstances where you may need a tier of judge that you can only access via the RCJ, and in those circumstances it's important to liaise with the Clerk of the Rules of the Family Division. Now, I have to say, the last time I tried to do this to get a COP case listed, the person that I was speaking with on that day was greatly confused about why I was contacting them rather than the COP, and ordinarily that would have been probably resolved by somebody actually physically going to the RCJ and getting the Court of Protection matter put in the urgent applications list. But I'm pleased to say in the particular case that I was dealing with, we eventually managed to find a suitable judge within the regions that could hear the matter, and a listing was achieved within about 4 or 5 hours.
And of course, there will be cases where it's simply not possible to apply within court hours. Now, the practice direction states that in these circumstances, it's necessary to make contact with the security office at the RCJ and to inform the security officer of the nature of the case. And again, the number is provided within the practice direction. Katie, I know that whether to bring an urgent application out of hours is something that is often tussled with. What thoughts are in your mind when you make this decision?
I think when you're considering an application out of hours, it's always got to be a careful balancing act. You don't want to risk incurring the wrath of the judge for bringing an application out of hours that could have waited until the next morning or until the end of the weekend. You really do have to be satisfied that if you don't make the application at that particular time, that P will be significantly disadvantaged or put at risk of harm of some form if this issue isn't dealt with at that particular time. There are always going to be some blurred boundaries and difficult calls to make, and that's the nature of our roles. And I think that's where it's really important to have a good team of people around you and to utilise counsel to make sure that you're working together to make that decision and bounce things off each other. Sometimes things can look desperately urgent, particularly late at night or over the weekend. And when you talk it through with someone else, there's a way forward that involves taking a more proportionate approach and not issuing out of hours. Sometimes it's simply unavoidable, and that's when we all need to spring into action. But certainly chatting it through, getting different perspectives is extremely helpful from my perspective.
Moving on to the third aspect of the roadmap. What notice of your application do you give? The practice direction is clear that, as a minimum, the applicant should take steps to advise the respondent or respondents by telephone or in writing of the application, unless justice will be defeated if notice were to be given. Now, the reason for this is quite plain. It's to ensure that the respondent is still able to advance their views at the hearing, even if that's by writing. Fourth, what documents do you use? The practice direction details that, wherever possible, an application notice in Form COP9, supporting evidence, and a draft order should be filed with the court in advance of the hearing. This ought to address the following matters. First, why the application is urgent. Second, whether it should be dealt with by a particular judge or level of judge. And third, whether it requires a hearing. Not all applications, of course, will need to be determined at a hearing. Some can be considered on the papers, often by consent. This all said, where there is exceptional urgency, an application can be started without filing an application form, if the court allows it. In such exceptional cases, therefore, an application can be made to the court orally. Now, the practice direction states that in these circumstances, a draft order should be provided at the hearing. The court will also require an undertaking by the applicant that the application form, in the terms of the oral application, and the evidence in support will be filed in either the next working day or as specified by the court. Now, clearly, if you're not filing an application form in advance of your hearing, you'll need to explain to the court office, if it's in court hours, or the security office at the RCJ, if it's out of hours, the same information that would go on the form. So, why the application is urgent, whether it needs a certain level of judge, and if it requires a hearing. Fifth, how does the hearing take place? During lockdown, hearings in the COP have been taking place by and large remotely. Katie, what's been your experience during lockdown of setting up the machinery for a remote hearing?
I think it's fair to say that it's got easier as time's gone on, but I suspect all of us found that right at the very beginning, when the various telephone hearing providers were suddenly flooded with this huge additional volume, that they were really struggling to cope. And many were turning around to solicitors and saying, we can't facilitate this, which is not something that I'd ever experienced before with providers like BT Connect. So we've had to be slightly more creative, and it's tended to involve discussions with individual judges. My experience is that certain judges prefer certain platforms, and it's always helpful to know which platforms the court would rather use. I think very helpfully, towards the end of March, Mr Justice Hayden produced his guidance around the various platforms that the court would accept and gave a clear indication of the platforms that were readily available to the judiciary. For example, I know that judges have Microsoft Teams and Skype for Business on their judicial laptops. There are also a number of telephone providers listed, some of which are less commonly known to practitioners, so it was helpful to have the full range. And if anyone is struggling to arrange a telephone hearing, I would certainly recommend looking at that guidance note, because it also contains contact details for the various different providers.
And it's worth noting that urgent applications out of hours often take place by way of a direct telephone call between the applicant's representative and the judge. Moving on to the sixth stage of the roadmap, the hearing itself, and specifically what duties are on applicants when an application is being made without notice. First, and perhaps the most important, there is a duty of full and frank disclosure. So this includes the applicant disclosing matters which suggest that the application ought not to be given. This will be expected by the court, and it's so that the court can be confident that it's appropriate for any orders to be made. The second duty is in relation to the evidence. It'll be perhaps no surprise to hear that during the hearing, the evidence will be subject to very close scrutiny. If the applicant isn't present in person to verify it, it should be accompanied by a contemporaneous note of the instructions. If additional information is put before the court orally, the court will direct the filing of sworn evidence confirming the information within a short period of time. The third is in relation to a note of the hearing, and Katie, this is where you also come into play in your role as a solicitor, isn't it?
Yes, absolutely. It's certainly extremely important to take as detailed a note as possible of any ex parte hearings. I mean, it goes without saying that that's important for all hearings, but particularly so for ex parte hearings, where you can and should be expected to share that note with other parties later down the line. It's important that it's as transparent as possible what matters were put before the court at the initial ex parte hearing and the reasons that the judge gave for either granting or refusing the application. And generally, it's practically impossible for counsel to be making the application and taking a detailed enough note. And so, in my experience, it should be taken by another member of the applicant's legal team wherever possible.
And that just leads us on to the order. If an order is made without notice to any other party, the order will ordinarily contain an undertaking by the applicant to serve the application notice supporting evidence, and any order made on a respondent and any other person the court may direct, as soon as practicable or as ordered by the court. There will also be a return date for a further hearing at which the other parties can be present. Now, Katie, I know you have some personal experience of service.
Yes, absolutely. Service is one of those things that's very straightforward, but also desperately easy to make mistakes in relation to. And I think it's important that even before you have made the order, or even before you're approaching the judge to seek the order, that you think very carefully about who you might need to serve it on, the reasons for that, and whether they need service of all documents, or whether certain documents should be either redacted or not given to certain parties. And I say this in the context of a recent case that I was involved in, where an urgent court of protection application was made to protect P from potentially quite significant financial abuse. And we made an urgent application to stop a transfer of a 6-figure sum, leaving P's account and potentially falling into the hands of a financial abuser. There were criminal investigations running alongside the court of protection proceedings that we had to be very mindful of. And some of the evidence that we had to put forward to the court to justify our application, if shown to the alleged perpetrator, would have prejudiced the criminal investigation into his conduct. So we had to ask the court for permission to only disclose certain parts of the court order and certain parts of the accompanying application to this individual, who needed to be able to have the opportunity to respond to discrete points. But clearly we didn't want to prejudice the bigger picture and the possibility of a criminal prosecution. So it was a fine balancing act between allowing this individual to respond, but also ensuring that we didn't encroach on the work of the police. The other point that I think that practitioners should be aware of when it comes to drafting orders and thinking about service is, in certain situations, it won't only be necessary to serve the order on those that you're intending to make parties, or those that you have made parties within that initial order, but also various third parties. So going back to the example that I used of the urgent application to prevent financial abuse occurring, we were also seeking permission to disclose copies of the orders on various financial institutions that we felt the alleged perpetrator might try and contact, to make sure that they were aware that they shouldn't be dealing with him in any way. So it's about thinking about it very carefully ahead of the hearing, getting the right order that you can serve on the right people to ensure that you cover all bases.
We've provided there a roadmap for bringing urgent applications in the court of protection. Shifting now to capacity evidence in the context of urgent applications. Of course, the first matter for the court will be whether it has jurisdiction to deal with the application. Specifically, it will consider whether there is evidence before it upon which interim declarations can be made, pursuant to Section 48 of the Mental Capacity Act. Now, sometimes, given the context of there being urgent circumstances, there can be difficulties in obtaining this evidence. For example, it may simply not be possible to access P. So how can professionals deal with this? The first thing to consider is whether there is a previous relevant assessment. If such an assessment has been undertaken recently, this is likely to be sufficient to satisfy the court. If it is less recent, for example, say 12 to 18 months ago, this could be relied on, but with updating evidence, for example, from a social worker, explaining why it is they consider P lacks capacity now. But what do you do if there is no previous relevance assessment? In such a scenario, attempts can be made to bring together evidence from relevant professionals, for example, a social worker, the GP. This would be regarding events and statements made by P. So this is all brought together so that you form effectively a capacity assessment. Now, it is imperfect, but the court can be satisfied with such evidence for the purposes of making interim declarations. That is, but there is reason to believe that P lacks capacity in a certain domain. If the court makes the order, you should set about providing the court with an up-to-date capacity assessment as soon as possible. It may also be necessary, of course, to consider whether an application should be brought under the inherent jurisdiction of the High Court as opposed to the Court of Protection. And Katie, what's been your experience of capacity evidence?
Yes, I mean, I think it's a bit like making the application in the first instance. It's a case of balancing up the evidence that you've got, looking at whether you can put together different points of view from the relevant professionals to put enough capacity evidence before the court, or whether you want to wait and get a clear capacity assessment that allows you to judge whether you need to issue your application in the Court of Protection or the inherent jurisdiction of the High Court. In a recent case that I dealt with, we felt that we needed to wait for a capacity assessment of some form in relation to a vulnerable individual with dementia, because there was really no capacity evidence at all and very limited professional involvement. I think there'd been one visit from a social worker, which the social worker had undertaken quite a cursory review, not attempted to perform a capacity assessment, and just walked away from a short general conversation with the view that the individual had capacity. I was instructed by P's daughter, who had clearly had much more substantial contact with her mother and had formed the view that she was very likely to lack capacity in the areas that we were considering within the application. And we therefore lined up a remote assessment from an independent social worker. We found an independent social worker who was available to conduct the assessment within 24 hours, and then I should say that included the time frame for producing a report, which was absolutely remarkable. But it shows that it can happen. If you need something done quick enough, you can make those arrangements. And it worked exceptionally well. The remote assessment was undertaken over 2 discussions of about an hour each to give P the time to sort of take a bit of a break and take stock between discussions. And what we received at the end of it was a really detailed, helpful report that assisted us and the court considerably. The report found that this individual lacked capacity to make certain decisions, and we were therefore able to clearly conclude that we needed to issue proceedings in the Court of Protection.
Well, thank you very much, Varsha and Katie, for such a comprehensive guide to the nuts and bolts of bringing urgent applications, and also for that particular set of hints about how to deal with capacity. Remote capacity assessments, telephone and video assessments are something we would never or very rarely have contemplated before the pandemic. And of course, it's something we've covered within the last 2 editions of this podcast. In particular, in episode 2, our guest speaker told us about his experience of remote capacity assessments, having undertaken many as he had. And it's well worth a listen to for people who want to find out more about this and feel more confident about using remote capacity assessments, which can in some cases enhance P's ability to participate and be evaluated. Moving on now to the next topic, the second we're going to cover, which is that of injunctions, another very practical topic. David Gardner's going to talk to us about this. And again, Katie's going to offer her perspective of injunctions from a solicitor's point of view. David, tell us about the law in the COP relating to injunctions. What are the principles? What is it we need to think about?
Yes, thanks, Adreeja. As with most urgent applications, normally we're thinking about those cases where P particularly needs to move from their current setting, or there's a particular contact issue with P where their rights are being affected. I mean, for example, see the recent case of BP and we deal with that in podcast 2, if you want to shoot back to that one. But I'm going to talk to you a little bit about injunctions. It's a topic which has some complication behind it, but it's also, I think, an important, useful tool that practitioners should be aware of and can often come up in an urgent context. Now, the first question that often people will ask, and not everyone knows the answer to it, is simply, does the Court of Protection have the power to make injunctions, binding third parties or respondents? Injunctions not necessarily binding P, of course. We're talking about third parties and other persons. So there's a cheats answer, a short answer I should say, and there's a long answer. Not too long, because we don't want to take up too much of your time with the podcast, but I'm going to go over both. The cheats answer is yes, and if you're asked by a judge to take them to the provision, is to simply take them to the Court of Protection rules. And the Court of Protection rules, Court of Protection Rule 10.10.1a, specifically refers to the court's power to grant the following interim remedies at 1a, an interim injunction. So on the occasion where I have been asked to take a judge to their authority, their power to be able to make an injunction on an interim basis, even an urgent interim basis, the easy way, the cheats way, is simply to refer to that paragraph within the Court of Protection rules. Now, the long answer can be found in the quite recent judgment of Re SF injunctive relief. And for those jotting notes down, as I'm sure you all will be, the citation is 2020 EWCOP 19, and it was heard by Mr Justice Keehan. Now, in that particular case, Mr Justice Keehan had started from the principle of he wasn't content that there was such power within the Court of Protection to make injunctive orders. Both counsel, as a spoiler alert, were able to convince him otherwise, and that's reflected in the judgment. But in fairness to Mr Justice Keehan, and in fairness to those advices I have seen, not from the counsel of this chambers I should say, but I have seen advices that suggest the Court of Protection doesn't have power to make injunctions. The long answer is not easy. Mr Justice Keehan takes you through his reasoning, and it's a useful guide if you want to take any other judges or practitioners or anybody else to the principles. Firstly, he refers to Section 47.1 of the Mental Capacity Act. That notes that the Court of Protection has the same powers, rights, privileges, and authority as those of the High Court. Now, in Re SF, Mr Justice Keehan noted that those are quite wide and ambiguous terms, but he was content that there was power by virtue of that section by using other elements within the MCA to bolster that view. He refers to Section 37.1 of the Senior Courts Act 1981 as well. So that's 37.1 Senior Courts Act 1981, which grants the High Court the power to make injunctive orders, so that's both interim and final orders. And by using that in conjunction with Section 47.1 of the Mental Capacity Act, that shows that you have the power within the Court of Protection. As I say, he relied upon other elements of the MCA, so he also referred to Section 17.1c, which permits the Court of Protection to prohibit contact between persons and P. And also he referred to Section 16.5 of the MCA, and that's where the orders that are made by the Court of Protection under Section 16 generally can be supported where the Court of Protection thinks necessary by other orders to give effect to those first orders. So he in effect used those various statutory powers to come to the view, no doubt assisted by learned counsel, that the Court of Protection does indeed have the power to make injunctions, both interim and final. He also refers to a couple of other cases from Mr Justice Hayden, and they're both worth a read. I won't go into too much detail on these, but there's a case of MASM, citation 2015 EWCOP 5, and a case of Whiting, 2013 EWHC B27 brackets FAM. In both of those cases, whilst not going through the showing of workings in the same way as Mr Justice Keehan did, Mr Justice Hayden expressly referred to the powers of the Court of Protection to make injunctions. I had always relied on those cases as my authority along with Rule 10.10, to instruct clients and indeed to be able to make it clear to the court that there was such a power. There's a bit of a wipe of the brow, certainly on my part, when the re-SF came out, really fortifying that point. Interestingly, there's no mention in re-SF of the power in Court of Protection Rule 10.10. Perhaps it didn't come into the consideration of the court, but there you go. I think there's both a short version and a long version that you can use to address the point. A few extra points that I think perhaps need to be taken into consideration if you are in the position of asking the court to make an interim injunction. Firstly, of course, whenever the court is making any kind of order, the court is bound by both Section 16(3) of the MCA and linking in Section 4 of the MCA. So any actions that the Court of Protection is taking, it always has to be taken in P's best interests. So you need to back up your arguments as to why injunctive relief is required by direct reference to how it is in P's best interests that said injunctions are being sought. In terms of some practical advice, within the case of MASM, Mr Justice Hayden made it very clear that really injunctions should be the last resort. It was suggested that the party should, of course, first liaise with the person, if at all possible, to whom the injunction will be directed, and if undertakings or other compromises can be effected to address the potential mischief, then that should be the way that the parties progress. There's also provision, if you want to refer to it, in the Part 21 of the Court of Protection rules that deals with enforcement. And there are some overlapping provisions that are helpful here. Because if you want to be able to enforce your injunctive order, then you're going to need to be able to, firstly, say that you have personally served it on the person to whom it is directed. That's Rule 21.6. And second, you'll need to ensure that there is a penal notice attached to it. That's Rule 21.9. Important points to remember because you want your injunction to have some force. The Court of Protection simply won't enforce by way of committal, and that is the way of enforcement, unless those provisions and Part 21 has been complied with. And whilst we're speaking about Part 21, if you are in a position where you're thinking you need to enforce your injunctive order, I won't deal with this in too much detail here because I'm really dealing with how to go about getting your urgent interim injunctions or your final injunctions by virtue of a reference to re-SF and the Court of Protection rules at Part 10. But if you need to know about enforcement, then do make sure you've read Part 21 of the Court of Protection rules and the case of re-whiting, which I referred to earlier. That will really cover everything you need to know about enforcement. Enforcement, of course, will need to be expeditious. You need to make sure the court's aware very quickly if enforcement is needed. If there are breaches of the injunctions, it's clear that the court should be informed quickly. But there's also a warning in there of the need to ensure that enforcement action is taken proportionately. So the parties need to have a good think about how they want to enforce and whether actually committal is something that is in the best interests of P and indeed everybody in the case. So that's how you go about getting your interim injunctions. That's the law behind the power of the Court of Protection to grant interim injunctions. And of course, were you doing so urgently, I wholeheartedly endorse everything that Varsha and Katie have already said to you about how to apply for urgent interim orders. Now, there are a couple of scenarios which may be useful for me to very quickly address, just to set out a type of situation where you may be thinking about applying for an interim injunction. And perhaps I'll deal with two that I've been involved in. The first type of case, for example, quite pertinent to our current circumstances. For example, if you are in a position, as I was, where P has been suffering some deterioration but has since recuperated. She was living at home and is then admitted to a care home, but is then ready for discharge back home. Now, if all parties, as we were in my particular case, were agreed that actually that's in her best interest to return home, then that's, of course, what the court is going to want to seek to facilitate. However, we were struck with a particular problem in this case, in that the protected party had a particular person who had for some time been living in her back garden. This particular person was known to encourage the protected party not to accept help from carers, which it was agreed by everybody she would need. He was known to act quite aggressively to P on occasion, and P had in the past expressed some fear of him. And to link it back to our current scenario, there was some evidence that he was aware and had capacity to deal with issues relating to COVID-19, but had made it quite clear to social workers that he had absolutely no intention of maintaining social distancing. So what do you do in that scenario where it's agreed that P should be returning home, but there is a practical barrier in the form of another person? Well, in that particular case, it seemed clear to us that it was in P's best interest for an interim injunction to be made against that particular person. Of course, that's going to need to be done on a relatively urgent basis, because the longer that P is awaiting discharge, the more time that she is not spending in her own home. So that's one example of a type of situation where you may need an interim injunction. A very brief other example is a situation at the other end of the spectrum where it was quite a young person, having just turned 18, who had made allegations of abuse against her father when she was very, very young. In that particular scenario, having just turned 18, she'd been recently contacted by her father with a view to getting back in touch and her going to visit him. He lives quite some way away. And there was some indication from P that she was going to go and do that, or that father was going to come and visit her. Now, P had no recollection of these allegations. So it's quite a tricky balancing act as to how you progress with the court of protection. But one point that all parties were clear on was father just turning up at the age of 18 at this stage was probably inappropriate. And there were concerns about the safety of P with regards to her father visiting her. So an urgent application was made by the local authority in that case to prevent any contact between P and her father. So in that case, you can see the need for urgency and the need for an interim injunction just to ensure that the risk of harm is avoided to P. It must be in her best interest in that scenario. So I just thought it would be useful to firstly go through the law, and secondly set out for you a couple of examples that I've personally been dealing with in and around lockdown as to where interim injunctions have been useful and have been granted by the courts.
Thank you very much, David. Katie, what do you think about the issues raised? David's raised some very important points about enforceability. And of course, there's no point having an injunction if it's not going to be effective. What about the respondents and issues about them? For example, where you're not sure if a respondent has capacity or may lack it.
Yes, it's extremely important to look at whether the individual that you are serving the injunction on is capable of complying with it. There are individuals, and we've all come across them in proceedings, that will willfully refuse to comply with injunctions, but there are others who are simply not capable for reasons of cognitive impairment. And I came across this issue in a recent case where an application had been brought ex parte by a local authority, and injunctions had been made in relation to a respondent in order to try and protect P within the proceedings. And everyone was rightly focused on P, but there had been no consideration of whether the respondent had capacity to be able to comply himself. He had a suspected learning disability. And although the injunctions were made when they were sought ex parte, when various other parties were joined to the proceedings and the issues were explored more fully, it became quite clear that the respondent simply didn't have any understanding of what the injunctions meant or what their implications were. And even when these things were explained to him in broken down terms, he was unable to retain that information in order to be able to successfully comply. So it's vital to make sure that your injunctions are going to be enforceable, and they clearly won't be enforceable if the person that you are injuncting clearly isn't capable of compliance through no fault of their own.
Well, thank you very much. to Katie, David and Varsha for their insightful contributions and in particular for sharing their real life examples of injunctions and urgent applications with us. On that note, I'm going to leave you with a quotation from Amelia Earhart. "The most difficult thing is the decision to act. The rest is merely tenacity." And with that in mind, it's bye from everybody at No5. We hope you've enjoyed listening to this podcast.